Hi there once again, and welcome to In Your Corner. John Scholes, Sivan, Tumarkin. We talk about injury law and sticking up for you, the little guy, is what we do in the show. If you've seen this before, you know exactly where we're going to go. This is information you need to know. If you're on disability or if you're dealing with an insurance company, we are here to cover you and inform you. Lots of stuff to get through today, pal. In fact, 3 situations when you must call a disability lawyer. That is coming up in just a bit. To contact anytime, 1-833-IN-YOUR-CORNER or inyourcorner.ca. Want to start with the week that was. What's been happening for you, pal?
John, it's been a very, very busy week as usual. Let me tell you about a story that really touched my heart. I had a call from a lady around the Ottawa area, and she called me because her husband suffered a stroke about 2 years ago. He's 53 years old. He was an airplane mechanic, and he suffered some paralysis, and he still has some cognitive issues, and even has some issues still eating. But his treatments have been pretty good, and he's been getting better and better and better, but he still has issues. He has issues with mobility, he has issues with, doing things with his hands, things like that. So he was on LTD for about 1.5 years or so, and then he gets a call from his LTD adjuster, from his long-term disability insurance company, and they say, look, we've looked at all of your medical records, and we've had our medical professional consultant, the consultant, take a look at some of the medical records that you've provided us. And we think that as you're approaching that 24-month mark, that 2-year mark, the magic number, yep, we think that you can do some other job. And of course, what does that mean? It means that the payments are going to stop.
Cut off.
And that's what happens in many long-term disability claims. And when they tell you that, that gets followed up with a letter that states that you are reaching the 24-month mark. The test for disability changes. Remember, within the first 2 years, you have to show that you can't do your own job to qualify for LTD. Beyond the 2-year mark, you have to show that you can't do any occupation, any job for which you're trained for or have education or experience. Yep. And so that's what happened to this individual. And so they're saying to him, to this person who still has issues with his memory and concentration and can't even walk properly, they're saying, we think you can do something else, which of course is ludicrous. His neurologist says that he can't go back to any form of work. His family doctor says the same thing, and some of the other rehab people have said the same thing. But of course, that letter from the insurance company invites him to then appeal that denial that's coming, right? And of course, I looked at the denial letter and I looked at the medical documents, and I said to her, I said, no, absolutely not. We can stand up for his rights. And that's what we're going to do, John. And that's what we do here all the time. We do here on this show, on the radio show as well. We educate people about long-term disability. We educate them about their rights. And I really want to make sure people understand you have a lot more power than you think you do against insurance companies. And that comes from me. And I used to work for insurance companies. Right. I used to defend them. I'm a lawyer. So that was an interesting case because it's not that different from many other cases. Whether you have depression or whether you have some kind of a chronic pain, the insurance company says, we're denying your claim, or they're saying, we've paid you enough, we don't think we should pay you anymore. In the vast majority of instances where people contact me, when they know that they can't go back to work and their doctors are saying they can't go back to work, I tell them they have a case, we pursue that case, and once we do that, the insurance company invariably comes to the table and tries to negotiate a resolution.
Is there ever a time where that either 2-year or close to 2-year phone call and letter doesn't arrive at your door? Or it's almost an arbitrary thing? Once you get to 2 years, you're going to get cut off.
In some instances, and it's rare for me to see that, but in some instances, no, they will actually take you beyond the 2 years. What's interesting are those cases, exactly that, where they've taken you beyond the 2 years, and then they turn around and say, oh, by the way, we think you can go back to work, even though nothing's changed. But John, listen, we have people who get denied off the bat just from the beginning. They're told you have no case for whatever reason. Maybe they don't think that you have sufficient medical support for your disability when your doctors have explicitly stated in letters that you are disabled. Or maybe they just simply think that, I don't know, you've done something that precludes you from getting LTD. The point is this: if you take their word for it, you are risking leaving a lot of money that is owed to you, underline the word owed to you, on the table and in their pockets.
Now, we didn't laugh. We both kind of grinned when you mentioned the denial letter. Please appeal. Feel free to appeal. Yes. We've talked about this before, but briefly, why is that a bad thing?
It's a bad thing because appeals are internal processes within the insurance company. What does that mean? It means that once you appeal their denial or the cutoff, when them cutting you off, you are essentially asking the exact same people who have just made that decision to deny you money that they owe you, you're re-asking them to reconsider their decision. Why would they reconsider their decision? Listen, I'm not gonna sit here and say that in every situation, 100% of the time, these appeals are never successful. That's not true. But then again, once in a blue moon, somebody wins the lottery too, right? All I'm saying is that what do we do different when we actually get involved in a case? Two main things. Number one, we are now standing between you and the insurance company. We are the ones dealing with the insurance company. You're not getting any more phone calls.
Nice.
You're getting no more letters, no emails. They're not allowed to communicate with you. They have to go through us. The second thing is we start a legal claim. And what does that mean? It means we're not dealing with that appeal nonsense. We are now exerting real pressure. We are taking the fight to them. Again, remember, I worked for insurance companies. I understand the pressure that happens when somebody starts a legal claim. And when an insurance company knows that you have called their bluff and that you are ready for a fight, especially when there's the right lawyer or the right firm on the other side, they will come to the table. It's that simple.
You know, you mentioned phone calls. We get a ton of phone calls on Lior's show, your partner's show, Employment Hour in 30. And a lot of those, because there's a lot of crossover between employment and disability, a lot of the phone calls are geared towards what we do here. So we get to a lot of those phone calls on the radio show. By the way, inyourcorner.ca, you want to find out where you can catch our radio show for the last several years. We'll get some phone calls and play them back, and I know we'll comment on them.
I've been off work for a month due to severe anxiety. I applied for disability benefits, but the insurance company denied my claim because they didn't agree with my doctor's report. My doctor says I can't return to work, but my employer says that if I can't return to my position within the next 2 weeks, I will be fired. What do I do?
The doctor says no, right?
Yeah, but you know, again, this is a perfect example of a situation where an individual who's suffering is getting squeezed from both ends, from the insurance company who's supposed to provide a safety net, and from the employer who's acting in a very cold-hearted manner and frankly against the law. So, you know, our firm deals with employment and disability claims, which means that we have lawyers that specialize in both, that have a practice focused on both. And what does that mean? It means that we can deal with both instances at the same time, and we can maximize the amount of money that our clients are owed and should get by law. Now, in this case, this gentleman who called in says his doctor says that he cannot go back to work, and clearly he cannot go back to work. Well, as far as I'm concerned, if the doctor is saying you are disabled from working, you should then qualify for long-term disability. But can the employer then turn around and fire you if you don't come back? You know what? If they do it at their own peril. Because if they fire you and you are disabled, not only are they do they owe you severance, which Lior, my partner, talks about all the time on his show, but it's a potential human rights violation. And again, why is it important to deal with both instances at the same time? Because if you get severance, if you are let go while you get long-term disability, your LTD insurer may be entitled to, in many instances they are entitled to a credit for the severance.
Okay.
But they're not entitled to any money you get for human rights violations. So you see, there are intricacies to those different parts of the law that are interlaced. And that's why it's important to go to a lawyer or a firm that can deal with both of these areas, because if you don't, and I've seen this happen before, people who have gone to an employment lawyer who has no specialty in disability law, and they come to me and I tell them, well, unfortunately, the way that case was handled, it's impacting your disability case now.
Yeah.
So it's very, very important to make sure that if you're having issues with work as well as your long-term disability, you go to, I think, a one-stop shop where the right hand speaks to the left hand.
I find it interesting that sometimes the insurance company will listen to the advice of the employer saying get back to work over your own medical practitioner who's saying he cannot work or she cannot work. I find that very curious.
You find that curious and you find that odd if you assume that the insurance company cares about you. They don't. Insurance companies are profit centers. That's what they are. They sell you insurance. I mean, think about all the commercials you hear on the radio and see on TV. Mm-hmm. It's all about we're going to be there on the rainy day. We're going to be there to catch you, to help you.
Take care of you. You're good.
It is nonsense. They are there to extract money from you or your employer if you're on a group plan. And they are there at the end when you need them to pay you as little as possible, if anything at all. What people need to understand is that when you have insurance, whether it's car insurance, travel insurance, LTD insurance, house insurance, you're not buying peace of mind. You think you're buying that, but what you're buying is a legal right to enforce your rights. The irony is that in many instances, you need a lawyer that deals with that area to enforce your rights. But you know what? That's just the way that the system works. I didn't build a system. I'm just telling people what's what and making sure people understand that if the insurance company tells you that you have no case, don't take that at face value.
3 situations when you must call a disability lawyer. We will get to that very shortly. Going to take a short break. 1-833 In Your Corner and inyourcorner.ca online is where you want to go. Back with more In Your Corner. Stick around. You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-833 In Your Corner, or go to inyourcorner.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca. And welcome back to In Your Corner, 1-833 In Your Corner, or help at inyourcorner.ca. You want to send along an email. We get to those on some shows as well. All right, 3 situations when you must call a disability lawyer. Listen to these. Maybe not write them down, but put them up in here, and they'll be there for good. Always useful information here on the show. Number 1, my brother, is when your long-term disability claim has been denied. Obviously, we talk about that every show.
You know, we talk about that, and that seems obvious, but it's not obvious to many people, and it's not obvious for 2 reasons. Number 1, people just inherently think that if an insurance company tells you that you have no case, they're denying your claim, that they are right. They must be right, right? I mean, their word is the word of God. No, far from it. Challenge the insurance company. Don't assume what they're saying is correct. Remember, their job is not to tell you the truth. Well, it should be, but their job in actuality is to make money for the insurance company.
So they make
money in 2 ways. They collect premiums, and they pay as little, if anything, as possible. All right. So if you get denied, you should absolutely call us, because we will tell you within minutes whether or not the denial is appropriate or not. And if it's not appropriate, what you can do about that. Here's the other reason why you must call a lawyer, because you may fall into that trap of doing this appeal. And it's not just one appeal. John, not a day goes by without people contacting me by phone, by email, by letter even, handwritten letters from more elderly individuals sometimes, who are saying, look, I've been denied. I've gone through 3 rounds of appeal. This thing happened 3 years ago. What can I do about that?
You're done.
Exactly. You're done. Remember, you have 2 years from the date you were first denied to start a legal claim. I'm not saying you should wait for 2 years. In fact, you should tell us immediately, call us immediately when you are denied. But that's what happens. You know, they get you into the cycle. They pull you in, right? The way Michael Corleone said, you know, just when I thought I was out, they pull me back in. But that's exactly what happens with these appeals. They pull you in. And so they'll deny your appeal. But wait, that denial of the appeal is going to come with a letter or an email that's going to have a paragraph at the bottom that's going to say, would you like to appeal again? Yeah? You know, provide us with some more medical documentation. Exactly. And again, and then a 3rd time. And in the meantime, you have no money coming in. You have bills you have to pay. You have increased stress at home. It's a horrible, horrible situation. So it's very important for people to understand, if you are denied long-term disability, you do not wait, you do not ignore it, you do not stash it or throw away the piece of paper. You give us a call or you email us. Let us take a look at that piece of paper. Let us take a look at some of those medical reports you've submitted. We will tell you within minutes, for free, whether or not the denial was correct or not, and if not, what you can do about it.
By the way, those appeal letters, to those at any time enlighten you to the 2-year time limit you have? Oh, by the way, you have 2 years to appeal this from us, me being the insurance company now, or they don't tell you?
Yes, they often do. Okay. They often do, but it's buried. And frankly, people are blindsided by the denial. And then, remember, the letter usually ends with that appeal paragraph, so that's what you remember.
Right.
You remember, it's the law of primacy, right? They teach you. You remember what happened at the beginning and what happened at the end. So you know that you were denied, and you know that now you can potentially appeal. Right? So that's what people remember. It's psychology. And we're going to talk about psychology a bit more when we talk about total disability and what it means.
Number 2 of the 3 reasons and times you must call a disability lawyer. That is, you've been receiving your LTD for a while, and now, as we talked off the top of the show, you're now told that your payments will be cut off.
So remember the individual that I spoke about, the lady that I spoke about at the beginning of the show that called me about her husband that suffered a stroke.
Yeah.
So he was on disability, and he was told, we are going to stop your payments, and I believe that the month was this coming June. So oftentimes when you're getting LTD, you are told in advance. In fact, in most instances that I've seen, heads up, we're going to cut you off in a week, in a month. I've seen one as far as 11 months from the time that the letter arrived. We see that as anticipatory breach. That is a legal term. That is what we argue the insurance company has now done. They have anticipated they've breached the policy
in anticipation
ahead of time.
Qualifying.
Exactly.
Wow.
And there is no reason, absolutely zero reason why, if you've received one of those letters or phone calls or emails telling you you're going to get cut off, and you know you're now ready to go back to work, and your doctors are saying you're now ready to go back to work, there's no reason why you should be waiting until you're cut off to contact us. And we've had cases, John, where people were told months in advance that they're going to get cut off. We got involved right there and then, and we were able to achieve a resolution for the individual and their family before the cutoff. So there was never a time where no money was coming in.
Nice.
And that's the goal. The goal is to make sure that you're not in a situation where you have bills coming in and nothing else.
Right.
You need the money to survive. We understand that. Time is of the essence.
1-833 in your corner, the number anytime. Get a hold of James or Sivan, who James is off today, but or anybody else in the firm for that matter. You want to reach out. 3 situations when you must call a disability lawyer. Number 3 is when your LTD insurance company threatens that if you don't do something they tell you, they're going to cut you off.
So that's very common, unfortunately, and this is a pressure tactic the insurance company uses. I would use a more harsher phrase. I would say that it's bullying, because that's what it feels like. That's how it's characterized, to me at least, by individuals who are experiencing it. Let me give you an example. You have a person who is told, we think you've made good progress. Our medical consultants think that you should be trying to go back to work. So therefore, we are going to put you in touch with someone who is going to help you to try and go back to work on a gradual return to work program. But you're not ready. And your doctors say that you're not ready. But they're telling you, unless you comply, which you have to under the policy, they say, we're going to cut you off. So it's a catch-22. What do you do? Yeah. Do you go against your doctor's advice? Do you make your own health worse by
scared
trying?
Enough to.
You're scared, exactly. Or what happened in a situation where the insurance company says, we want you to try this kind of treatment. But your doctors are saying, no, that's not appropriate for you. And the insurance company says, but if you don't do it, you're in breach of the policy. You don't have to do everything the insurance company says unless it makes sense for you medically and your doctors agree with it. And, insurance companies are going to be angry at me saying that, because from a technical standpoint, it's true. You have an obligation to comply with their reasonable requests under the policy. But it's unreasonable, as far as I'm concerned, to ask you, John, to go back to work, to try and go back to work, if you are still unwell and your doctors are saying it's against medical advice. It's not fair, and I don't think it's lawful for them to pressure you and to cut you off LTD if they want you to undergo some kind of a treatment and your doctors are saying that's not the appropriate treatment. And I would fight that. I would take the fight to the insurance company. And here's the secret. When we challenge insurance companies on those points, John, they concede. They know that if this ever went before a judge would slam them. But they are betting, it's a betting game, they are betting that the vast majority of people who they try to pressure will bend and break under pressure. And either will do what they want them to do, go back to work against medical advice, for example, or simply get off claim.
Are they going to do this if their so-called medical consultants haven't even seen you? They're just reading a paper file. How can they possibly make that statement? They don't know you from Adam.
That's very true. And in fact, some of these consultants are not even doctors. And some of the doctors that they use are doctors that don't have the specialty in the type of illness that you're experiencing. I mean, when we start a legal claim, the insurance company then legally has to provide us with a copy of their file so we can actually go through all the notes. You know, James, my partner, likes to talk about that because for him it's actually a game. It's a cat and mouse game. He loves going and poring over the insurance company's adjuster's records and notes that the insurance adjuster has made and catch them in little mistakes and big mistakes sometimes. Why? Because insurance companies, again, are there to do one thing and one thing only, which is to make money. And the way they do it is they cut you off or they pay you as little as possible. And once we start that legal claim, they can't now hide any of those documents. And so we can take a look at what their medical consultants have done or said or seen. But yeah, it does happen a lot that they have consultants who haven't even seen you. They've just, you know, looked a little bit, you know, through your medical records and they've come up with their own opinions, irrespective of the fact that you've had doctors treating you for years.
Right.
It's ludicrous. It's absolutely, and insurance companies know it. They know. How do they know it? Because when we start a legal claim in those cases, they come to the table and they bring their checkbooks.
Right. Help@inyourcorner.ca is the email address. We'll get to one from Marco. Marco says, you keep getting questions from people about the phrase total disability. We talked about this the other week with James as well. Can you please explain in more detail what does this mean in the context of LTD? Does it mean that people need to be in a coma to qualify for LTD?
You know, that's a very good question. I think we're going to start talking about this more and more because what's happening out there is that people naturally, and I don't blame them, look at the phrase total disability and they focus on the word total. And when you think about total, you think about complete. You think about paralysis. You think about brain injury. You think about, you know, something.
Vegetative state, you can't do anything.
Exactly. That's what I would think.
Yeah.
No, nothing can be further than the truth. That's absolute nonsense. And while I don't have the information to back this up, I suspect that this phrase was concocted by insurance companies to dissuade individuals from fighting legitimate LTD claims.
Effective.
Because here's the thing. Total disability, what that means, and it's generally defined in the LTD policy, it just means that you can't do substantial portions of your job. If you've had a stroke or you have chronic pain or you have depression, whatever it is, and you cannot function in a way that allows you to complete the main aspects of your job, you can't earn, let's say, 2/3 of what it is that otherwise you would be earning through your job, then you would qualify under most policies for total disability. It does not mean that you have to be in a coma. But when an insurance company sends you a letter saying there's insufficient medical documentation to support the fact that you are totally disabled, you're thinking, oh my God, yeah, that's true.
I'm sitting down.
I'm
gotta
sitting
go back
down.
to work.
Maybe I can.
They called me out.
Yeah, maybe I can walk a bit. Exactly.
Yeah.
No, it's absolutely nonsense. Yeah. That's not what it means. The test does change at the 2-year mark, like we spoke about before. But even at the 2-year mark, you don't have to be in a coma or a vegetative state. All you have to show is that you cannot work because of your disability. And then you should qualify. And if you don't, we can fight that.
What you should do if your insurance company tries to use your social media against you, that is coming up when we come back from a short break. 1-833-IN-YOUR-CORNER and help@inyourcorner.ca for email like we just read out. In Your Corner continues. Stick around right here.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to In Your Corner. You want to reach out any time for Sivan, for James, who's not here today, or anybody at the firm, 1-833-IN-YOUR-CORNER and inyourcorner.ca. MyDisabilityQuestions.com. That is another fantastic resource you can use. You simply ask your questions. There's a drop-down menu. there's a pretty high probability that your question has been asked already and answered in depth. If not, leave it there, and Sivan, one of his team, will get to it. I'll throw one at you now, Sivan, from, again, mydisabilityquestions.com. Says, I work as a manager in a large company making $115,000 with bonus. It's a good gig. I've been struggling with depression all my life, but after last year's divorce, it got worse. My psychologist says I can't work, but the insurer says that if I don't return soon, you know the next words, I will be cut off. Right. I'm not ready to go back, but I'm afraid to tell the insurance company that.
So again, that's an example of what I call a bullying tactic. I mean, the psychologist specifically says that this person cannot go back to work. And you know, you're dealing with somebody who's making six-figure salary. You know, that person has a high-stress job. That's not to say that you have to have a six-figure salary to have a high-stress job, but my point is that this person, managerial role, I mean, clearly his psychologist has diagnosed him with something that he believes or she believes prevents him from going back to work at this point in time. Who is the insurance company to decide otherwise? They're not the ones treating him. They're not the one who have his best interest at heart. So this is exactly the type of case where I would tell this person, I would want to see what the psychologist actually wrote down. But assuming it says exactly what we just discussed, which is that he cannot go back to work at this point, this person, I would fight them. And here's the interesting thing. He ends that question by saying, I'm afraid to tell that to the insurance company. I will tell the insurance company. Let me deal with the adjuster. By the way, I love doing that. I love dealing with adjusters. I love even more dealing with defense lawyers, right? Because, again, I used to work as one in the past.
Plus, they get it.
They get it. Right. You know how many times I've sat across a defense lawyer on a case like this, and, you know, off the record, we've had a discussion, and the defense lawyer just goes like this.
And he's like, here.
And just says, I have no idea what my client was thinking. Wow. They tell me that.
Wow, that's incredible.
You know how many times I've done that myself? Yeah. You know, to the other side. Again, off the record, without prejudice, you know, you're not compromising your client's claim, but you are, you know, insurance companies understand. But here's the thing, and this is what this person who just wrote this question, you know, he's done the right thing in asking the question, because the majority of people don't even ask the question. They just take that at face value that they have to go back to work. You don't. Listen to what your doctor, listen to what your psychologist, whoever's treating you, listen to what they're telling you. And then assess for yourself whether or not you are able to go back to work and whether or not you are not able to go back to work. And if you are able to go back to work, go back to work. Absolutely. I'm not telling you, you know, mitigate. Yeah, don't be off work just for the sake of it. But listen to what your treatment providers are saying and listen to your body and your mind, and then make that decision. But do not be bullied by the insurance company.
I think we got time to slide an email in. Again, if you want to send one along anytime, we'll get to it on a future show. If not now, help@inyourcorner.ca. This one from Julie says, I reached the 2-year, 24-month mark with my LTD disability, and now my insurance company says that I don't get any more benefits. I'm done. I'm 46 years old. I checked my policy, and it says that I should be able to get to my benefits until I'm 65. I don't understand. Why are they ending my payments? What do I do?
Well, first of all, Julie did the right thing in checking her policy. And I tell people all the time, you know, we have to look at your policy, because different policies have different provisions. Many of them are very similar, but policies do differ. And you know, Julie is right to have seen exactly, you know, to have tried to figure out, you know, what is the cutoff point for LTD. And
I'm not 65, not even close.
So in the vast majority of policies, it's 65. Okay. Some policies are for less time, 2 years, 5 years, 10 years. Some of them are beyond age 65. But it's very, very common for people to be told, you've reached that 24-month mark, that 2-year mark, you're no longer eligible for LTD, when in fact that's not the case. What the insurance company is essentially trying to say, except they say it in a way that is not often clear, I think in some instances to mislead the individual, is that they think that you don't qualify for LTD beyond the 2-year mark. Remember, for the first 2 years, you only have to show, you have to prove that you can't do your own job. Beyond the 2-year mark, you have to show that you cannot do any job. Don't take it at face value when they tell you you're going to get cut off because your policy is only a 2-year policy. Right. Check your policy and check with us.
Will they send you for an assessment for beyond that 2-year mark?
Absolutely. They will. Absolutely. In many instances. Or they will have consultants review your file.
Of course they will.
Right? And then they'll make a decision, most likely to terminate you.
Last 30, take it home, pal. What do you think?
Listen, I think it's important. We've been doing this show for a while now, and we've been getting very good feedback. And I want people to understand you have power. You have a lot more power than you think you do. Don't let insurance companies bully you. Don't let them pressure you. And don't let them convince you that you have no case and then you're not owed these benefits when you really are. Give us a call, email us. We'll talk to you.
Good stuff. We'll leave it there. 1-833 in your corner and inyourcorner.ca. Thank you so much for joining us. We will catch you right here next time.